Welcome once again to Lehto's Law. Here's Steve Lehto.
Michael sent me a note. Steve, check out the story from stlpr.org, and it's about a man who was exonerated of a crime he was accused of and convicted of in Missouri, and the attorney general there wants to keep him in prison despite the fact he's been found actually innocent, and a court has ordered his release. Now, here's the thing. People are going to want to argue about something, and they want to say, hey, Steve, let's look at the facts of the case and discuss whether or not this guy actually did it. And here's the thing. There were trials and hearings and all kinds of stuff that we probably couldn't summarize in any meaningful way on a video here. But what we're talking about is the theory, the hypothetical. Imagine a situation where somebody gets convicted of a crime. Some time goes by, and then, for whatever reason, it's discovered that that person did not do it. They are not guilty. They should not have been convicted. In that instance, should that person get out of prison because they are actually innocent, or should they be held because our legal system said so? That's what we're talking about here. So there are people who say this guy here is actually innocent, including a court. And the attorney general's like, no, I don't think he should get out. So in his case, you can argue about the facts. But in the hypothetical, theoretical world, the question I'm asking is, shouldn't a person who's been proven innocent be allowed to get out of prison? Or do we say, well, hey, they're convicted, fair and square? So Danny Weissentowski wrote this story. The Office of Missouri's Attorney General has spent recent years opposing the release of people found to be wrongfully convicted, even when courts order them to be released. One issue is an extended legal battle regarding actual innocence, which, by the way, is the hardest standard to meet. People go into court all the time and say, I got an unfair trial, judge made a mistake, evidence wasn't turned over, et cetera, et cetera. But when somebody comes into court and goes, no, I'm actually innocent and I can prove it, if they can meet that burden, that's the hardest burden to reach. A 2021 law changed all of this regarding claims of innocence, leading to the release of several individuals. Not thousands of people, several. And some of them had spent most of their lives in prison, which included a man named Christopher Dunn, D-U-N-N, Dunn. He served more than 30 years locked up before his conviction was vacated last summer by a St. Louis judge. Despite that, he's still having legal issues. Last month, the Missouri Attorney General's office presented arguments to the state Supreme Court that they should be allowed to appeal the release. Innocence has never been enough, according to the Attorney General's office, Dunn told this reporter. Right now, I'm just sitting here waiting to see if the Missouri Supreme Court is going to rule with the consciousness of the law. While Missouri's Attorney General continues to appeal this case, the office is also opposing a bill introduced recently to expand the scope of who can legally submit a claim of actual innocence. Under a law from 3 or 4 years ago, prosecutors in the county where the conviction occurred must seek to evaluate cases for possible innocence. The new bill would allow people currently in custody to initiate a claim of innocence even if they're not on death row. So apparently they'd limited it to people on death row originally, and they've now expanded it. The bill recently received a public hearing in the House Judiciary Committee. Dunn and several other exonerees testified in favor of the bill, but the bill was opposed by First Assistant Attorney General Jay Atkins. He criticized the bill for not including victims as part of the expanded legal process for making claims of innocence. He warned the bill would lead to tens of thousands of claims flooding the court system, adding that the proposal undermines our system of justice in a way worse than any bill I've ever seen. Now, let's back up for a second. Let's assume that they're going to actually entertain people who say, I can prove I'm innocent. And this man says, well, we should bring in the victims and let them testify. No one's saying the crime didn't get committed. They're saying the crime was committed, just not by this person. And here's the thing. I've seen probably over a dozen cases where somebody was convicted and they interviewed the family members of the victim. And the family members go, we're so glad to see this person get locked up for what they did. Later on, it was shown that this person was innocent and got convicted wrongly and got let out. Then they go and interview family members again. And I've seen family members go, well, it's disappointing because we thought that was the guy, but it's not apparently. We just hope they find the right guy. I've also seen people say, well, they shouldn't have let him out until they found the right guy. Or I still think he did it. And I can tell you that I've seen that and all manner of everything in between. And I can understand that if I was related to a victim of crime and I was upset by the crime and they caught somebody, so we got this guy or gal, and the jury convicted them, I can then say, okay, good, they got the person locked up. Legal system worked. So if somebody comes along later and says, no, this guy or gal didn't do it, they're actually innocent. What? And that would cause you to have a problem because something you believe for so long is now not true. But if the person's actually innocent, do you want them locked up just because you want someone locked up, or do you want the actual person locked up? So a criminologist and professor at St. Louis University testified in favor of the bill, and she pushed back recently on the opposition from the Attorney General and the Assistant Attorney General. She said, I think the greater miscarriage of justice is the fact that we have people who are sitting in prison for things they didn't do. The Missouri's Attorney General's fixation on preserving convictions is a consistent position, according to an attorney with the Brian Cave Leighton Paisner. That's a law firm, apparently. As long as I've worked with them, they have just unqualifiedly been opposed to anyone applying for innocence. It's confusing and puzzling why they would do that, because we're all in a justice system. Justice should prevail here. The common sense that someone is innocent should not be kept in prison. There shouldn't be a debate on that. So his past legal work has led to the release of 5 people, all found innocent after spending years in prison for crimes they did not commit. He's also part of the legal team assembled by the St. Louis Circuit Attorney's Office, which successfully argued for the innocence of another man back in 2022. So he was there discussing this case as well. And again, I understand that there are 2 issues here, and one of which is there are people who just say, hey, you got convicted, you're guilty. Okay. And I understand people who say, but Steve, you know that you can't always prove your innocence. You can't. But there are some situations. Where they can absolutely prove that, okay, this person didn't do it. And the main thing that's happened is the change in technology in examining and decoding DNA that's occurred in the last 30 years. Because there was a time when they would actually say, we've got DNA samples from the perpetrator, because where the DNA samples were found and what the alleged crime is, and we know who that, we have that, but in the time before they could do DNA testing on it, because remember, some people have been in prison for 30, 40, 50 years. And it turns out now, if the samples are still around, they can be tested. Oh, it matches somebody else. And I've had people really contort their logic and go, well, what if 2 people were involved? Well, no one ever said that until just now. So I don't know. But one of the things I'd like to point out is that there are attorneys, prosecutors, AGs who think their job is to win at all costs. If you put someone in front of me for me to convict them, I will convict that person and I'll win. And that's not really the job, but that's what inspires prosecutors, for instance, to forget to turn over exonerating evidence to the defense. Oh, we forgot to give you that. We gave you 10,000 documents, but the one document we forgot to give you is the one that would have actually helped your guy. Sorry. And they shouldn't be motivated by their desire to win, okay? And I've given this example before. I think I did a video about it years ago. But there was an occasion where there was a crime committed. A crime was committed. And the police were convinced that 2 different people could have done it. So they tried the people individually. And at the trial of the first person, they said this person did it acting by themselves and got a conviction. They then later tried the second person, arguing this person did it acting by themselves. Jury convicted that person. Second jury didn't hear about the first case. And so you have a situation where two different people are convicted for a crime that, according to the state, could only have been committed by one person. By definition, one of those two people is innocent, according to the prosecution's theory. And so that should be a problem, shouldn't it? And so again, the fact that the Attorney General is fighting this, and is he fighting it on the grounds that the guy isn't innocent? Or is he upset with the process? Because talking about the effects it's going to have on the legal system, you understand, again, the bar is very, very high. And if you think that it's going to cause people to file frivolous actions, you might not know as much as you need to know about the legal system. Because there are quite a few people who are in prison and they got a lot of time on their hands and they file legal actions, whether it's appeals of their own case or lawsuits filed in federal court against their jailers or whoever they think has wronged them. And there already are a whole host of things being filed by prisoners. And so I haven't seen the actual bill itself yet, but I have always believed that if someone can prove they are innocent, then that needs to be looked at, and if it's been proven, the person should get out of jail. Innocent people should not be sitting in prison, especially not for the rest of their lives, for something they didn't do because the prosecution and the jury got it wrong. And that does happen. It does happen. So it doesn't happen a lot. I'm not saying it happens every single day or anything, but no one's claiming that there's, thousands and thousands and thousands of people who are going to get out. They're just worried they might get thousands and thousands of claims filed. But all they got to do is have a screening process that basically says, what evidence do you have of your actual innocence? You can't just sign a thing that says, well, I didn't do it. It's got to be more than that. So, Michael, thanks for sending that from stlpr.org. Chris Dunn was exonerated, but the Attorney General of the state wants to put him back in prison. And Danny Weissentowski wrote that. Questions or comments, put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. Travel light. Don't carry the weight of the world on your shoulders.